Well, good morning, Jaginder Rana here. The topic of the day is insurance litigation in India. Insurance litigation in India. The insurance litigation in India has been increasing in recent years, with a rise in the frequency and severity of claims. Professional indemnity and directors and officers' claims have also contributed to the increase because these are the most common types of claims, and the number of claims and the amounts being claimed have both increased. Employment practice liability claims. While these claims were previously usually made in other jurisdictions, more are now being made in India, and with high value settlement demanded. The next one is cyber claims. These claims are increasing rapidly, in part due to the rise in cyber incidents like phishing attacks and ransomware attacks. The high legal fees required to defend claims can be a significant factor, and the delays in the court systems can mean that claims can take years to resolve. So some reasons for the increase in insurance litigations includes: there is an increased awareness of business risks. The awareness of business risk increases, so does the likelihood of the insurance claims. And then the legal and regulatory framework tightens, so does the likelihood of the insurance claims and litigations is there. And the government has taken steps to improve the business environment, including setting time-bound measures for resolving disputes. So, in the absence of any reference to arbitration under the terms of a policy, insurance disputes can be litigated both before a civil court or a consumer forum. If the insurer initiates the litigation, it has to be before the civil court and consumer forum can entertain such disputes. Both the civil and consumer courts have territorial and peculiar jurisdictions, and the civil court or consumer forums before which the matter is decided is dependent on the value of the disputes and the geographical limits of the office of the defendant insurance company within which the cause of action for the dispute arose. So the broad ascending hierarchy of the civil courts comprises roughly 600 district courts, 24 high courts, and the Supreme Court of India, so which is the highest court of law in India. 4 of the 24 high courts, Delhi, Mumbai, Chennai and Calcutta, have original jurisdictions to hear matters over a certain pecuniary value. So the civil courts and judges under them do not hear matters involving value higher than that limit. In all other cases, district courts and the competent courts of first instance have an unlimited pecuniary jurisdiction to hear any insurance disputes. So there is no right to a hearing before a jury, and cases are decided by judges. So the consumer courts follows a 3-tier hierarchy. In ascending order, the district, state and national consumer dispute redressal commissions, NCDRC, National Consumer Dispute Redressal Commission. There are 626 district consumer dispute redressal commissions which can accept claims up to a value of approximately $29,500. There are 36 state consumer dispute redressal commissions which can accept limits of up to approximately $1,48,000, and appeals against the decision of the district commissions. At the apex is the NCDRC, that is National Consumer Dispute Redressal Commission, which accepts matters with a value of over $1,48,000 and appeals against the decision of the state commissions. So for quick resolution of the commercial disputes, commercial courts were set up by the government in 2015 through the Commercial Division and Commercial Appellate Division of the High Court Act 2015. So the Commercial Courts Act defines commercial disputes to include insurance and reinsurance disputes. Commercial courts can accept a dispute of values and exceeds US dollar 1,48,000. So insurance and reinsurance disputes that exceeds US dollar 1,48,000, if not heard before the consumer fora, will now be heard and decided by the commercial courts. So by way of recent amendment in 2018, the pecuniary jurisdiction of the commercial courts has been reduced from US dollar 1,48,000 to US dollar 4,170. So in the case of commercial suits, unless the party is seeking an urgent interim users, the Act prescribes that the parties must compulsorily mandate before the suit is filed. As far as cause of action is concerned, it depends when do insurance related cause of action accrue. If a dispute between the insured and the insurer usually arises when the insured's claim is rejected in part or in full. So by the insurer and which the insured believes is covered under the policy. There can be a disagreement between the insurer and the insured in relation to the scope of the insurance clauses, the quantum payable under the policy, the applicability of exclusions or compliance with the policy terms and conditions, etc. Under the Indian Limitation Act of 1963, the cause of action for the purpose of calculating the limitation for filing a suit against the insurer will commence from the time that the claim is denied or the date of the occurrence causing the loss. So the prescribed limitation period for filing a claim in the civil court or an arbitration is 3 years, whereas the limitation period for filing a claim in the consumer court is 2 years. So what preliminary procedural and strategic considerations should be evaluated in insurance litigations? In fact, procedural considerations include identification of the appropriate limitation period and jurisdiction for the institution of the litigation in relation to strategy. But it is important that the preliminary objections to any suit, such as expiry of limitations, are brought to the court's attention at an early stage to attend a dismissal on the basis of the preliminary objections. However, in India, it is very often the case that the preliminary objections are decided after the substantiative pleadings are complete, as the courts are unwilling to decide without having had access to all the documentations on the matter. So what remedies or damages may apply? The relief available in Indian litigation in cases of insurance disputes are specific performance and claims for damages. In the proceedings, the insured can either require the insurer to specifically perform its obligations under the policy or to pay the claim amount. Indian courts and tribunals have discretion to award interest from the date when the cause of action arose until the enforcement of the judgment. So interest is usually awarded at a rate of 9 to 12% and in certain cases based on the conduct of parties, interest of 18% is also awarded. So the courts may also award the successful party its cost, but the award is at the court's discretion. It is common for cost awards to be made in favor of successful party. But the level of cost awarded is rarely sufficient to cover the actual cost of litigation. So referring to a statutory upper limit of 4,000 rupees for cost awards in the case of vexatious litigations, the Supreme Court suggested that the Parliament should consider raising the limit to 1,24,000 rupees. In view of the low level of cost awarded, there are as yet no material advantage in making a pre-trial offer in civil litigation. So, Elder bank letters are hardly used in a commercial suit. The statutory limits for cost do not apply, thereby allowing cost to be awarded in accordance with the actual expenditure incurred by the winning party. So, award of cost is not compulsory and remains at the discretion of the court. In relation to interim reliefs that are available in general, they include temporary injunctions and interlocutory orders that are provided for under the Civil Procedure Code of 1908. Parties also seek interim mandatory injunctions that are available under the Specific Relief Act of 1963. So, a court may issue a temporary injunction restraining the act or omission to act to make an order for the purpose of staying and preventing the alienation, sale, removal, or disposition of a property in appropriate cases. Interim relief also includes ordering the insurer to pay the insured the admitted sums payable under the policy so that only the disputed amount remains to be adjudicated upon. It is for the court to decide whether any interim relief should be granted, the terms on which it should be granted, and the duration of the relief. So, under what circumstances can extra contractual or punitive damages be awarded? Indian contract laws does not permit the awarding of extra contractual or punitive damages in cases where no damages have been stipulated in a contract. So the court awards reasonable damages and that have been incurred by a party. Even in contracts where the damage amount is stipulated, there is a degree of reasonableness attached to the amount the court would ultimately award, and courts always examine the actual damage incurred. So the court will examine whether the amount stipulated is in the form of a penalty and can reduce the amount if it is of the opinion that the stipulated sum is a penalty. So the Supreme Court settled the law in this respect in Fatehchand versus Balkishan Das, AIR 1963, Supreme Court 1405, and has reiterated the same in subsequent case laws. So under tort law, Indian courts are also slow to award any form of punitive damages. The compensatory damages are usually awarded. In some rare instances, punitive damages have been awarded by the courts. These, however, relate to environmental damages cases, unwanted damages cases, and cases of negligence where loss of life is involved. So, the practice of increasing the litigations in the insurance matters is not a good sign, in fact, because the number increasing is neither good for the insurance companies nor the judicial authorities. As insurance litigation is particularly diverse and nuanced within a wide variety of underlying claims, it is crucial to be able to hone on the litigation trends in these different subsets of cases as we do in this report. Because insurance legal data experts and editor of the report says, we gain important data-driven insights into these shifts and patterns because in 2023, 17,644 insurance cases were filed in federal district courts. In the 3-year period from 21 to 23, the highest number of insurance cases was filed in the Eastern District of India. Insurance companies dominated the list of the most active plaintiffs and the most active defendants. For insurance cases that were appealed, there is again long time litigation. So, increase in litigation in India is no way good, because ultimately IRDA want the strong grievance redressal mechanism so that the litigation does not increase, and consumers gets the immediate relief. Moreover, it is the duty of the insurance company to settle and resolve the grievances of the insured, because the duty to defend clause in an insurance policy essentially states that in the event of a claim being made against the name insured for an alleged wrongful act, the insurance company providing coverage at the time has the duty to defend the claim, even if it is subsequently found to be groundless, false or fraudulent. Therefore, although the claim lacks merits, the insurer still has an obligation to defend the claim. So there does not appear to be any Indian case law relating specifically to insurer's breach of its duty to defend. This issue is a subject of dispute in the cases. So this does not necessarily mean that the company is liable for more than its policy limits, unless the insurer has acted in bad faith by refusing to defend its insured, or by failing to act reasonably to settle a claim within its policy limits. It is not liable for that portion of the judgment or settlement in excess of its policy limits. So an unjustified refusal to defend does not arise where the refusal to defend is based upon a conflict of interest. Further, an insurer has not unjustifiably refused to defend where it has offered a defense under a reservation of rights, but the insured rejects the reservation of rights. Where coverage is in question, the insurer is not required to provide an unconditional defense. So insurance companies have to render smooth services so that the litigation does not increase. Thank you very much.